Well, welcome back. And of course, the term with the Supreme Court is over, and a lot of those decisions have been coming out. And there's a lot of concern about some, and happiness about others, and contention about some. Always an honor and perfect timing when we have time to sit down with Jim Burling. Jim is now the senior legal counsel there at the Pacific Legal Foundation. And you can go to pacificlegal.org is their website. And let me say this organization is frontline fighting for you. So check them out, support them. That's pacificlegal.org. Jim also has a fascinating book called Nowhere to Live, The Hidden Story of America's Housing Crises. And he hits the nail on the head with this issue. You can get that online. Check it out. I think you'll find it to be a fascinating read. And that is called Nowhere to Live, The Hidden Story of America's Housing Crisis. Jim, good to see you, friend. How are you, buddy?
I'm doing well. Great to see you, too.
Okay, so the term is over. Are you sleeping now?
Once I finally got through reading the decisions, which is like reading several novels at once.
There you go. Your 30,000-foot view of this session, what did you think?
I think the court did what it needed to do. It really increased the president's power where the Constitution said so, and it limited his power where the Constitution said he could not do some of the things that he wished to do. I think overall, it's a good case for religious liberties, the rights of parents to control the fates of their children. And I think, by and large, people will look back at this as a very consequential term in terms of outlining the constitutional parameters and the separation of powers and where the president's power begins and ends.
Have we ever seen a term where it dealt so much with separation of powers?
Certainly not in my lifetime. Okay. I think maybe back in the New Deal era, where the court for a while pushed back against President Roosevelt, and then eventually, as we all know, decided to go along with. There's some changes of personnel, and it just acquiesced to whatever President Roosevelt wanted. But one of the key cases from the New Deal, which limited the president's power, that is President Franklin Roosevelt's power, was reversed to this term. So I think this is a very consequential term.
All right, let's take a look at some of the cases. Of course, one of the big ones is the birthright citizenship. Very controversial. What did you think of the ruling?
I think the ruling was what we expected to see. It went a little further in some ways than I thought. This is based on the citizenship clause of the Constitution that says that people that are born here subject to jurisdiction of the federal government are citizens of the state and federal government, state where they're born, in the federal government. The question, though, is what does you mean by subject to the jurisdiction? And this is where the big controversy between some of the justices were in this case. With the case of the majority, and Justice Roberts and 4 other justices, including the liberals, they said it means if you're born here, you are, and your parents are subject to the jurisdiction of the federal government. Therefore, you are a citizen. Others, like Justice Thomas, in a very long 91-page dissent, said, no, it's not simply being born here, it's being domiciled here. Now, what's the difference? He said that being domiciled here means that the parents of the child, not only are visiting here, but they're intending to stay here, and they're intending to be under the jurisdiction of the federal and state government and not under the jurisdiction and have no more loyalty to their home country. And so he saw a distinction there. But I think Justice Roberts was rather pragmatic in ruling that no, citizenship applies to anybody born here, because I think he saw some of the procedural difficulties in trying to apply a domicile requirement. How do you know what people intend? How do you prove that you did or did not intend to stay here and be subject to United States jurisdiction? And so I think Justice Roberts, being a very pragmatic justice, sometimes his pragmatism gets ahead of principle in some respects, but I think he realized that he thought, at any rate, this is the only result that could, something that could be used and could be worked with in the future. So we have birthright citizenship, as we've had now for many years, and President Trump's attempt to rescind that failed.
Okay, a couple more questions on that case. How do we solve the anchor baby problem?
You know, I think you could, if you have legislation making it illegal to come here for the purpose of giving birth and leaving, perhaps holding the people that hold these birthright tours liable, It's a difficult problem. I think legislation is going to have to be tried and see if it's constitutional or not. I mean, the problem is, of course, when the Constitution was written and the 14th Amendment was adopted in 1868, we didn't have airlines, we didn't have birthrights, we didn't have the ability of people coming here and staying a few weeks and having a child and leaving again. It would have been unthought of back then. But during oral argument, Justice Roberts, in response to that argument that we didn't have airplanes in 1868, said, but we've had the Constitution for at least that long, and the words of the Constitution haven't changed, although other circumstances have. So I think we're going to have to try legislation and see if anything works to solve that problem.
I forget what justice, maybe it was Alito, one of the other ones that kind of gave an open door to an argument to challenge this. Who was that?
Well, Justice Kavanaugh said that he didn't think it was the 14th Amendment that really ruled here, but it was the Citizenship Act of 1940. And the Citizenship Act of 1940 adopted an older opinion from the Supreme Court many years prior that said birthright citizenship is the norm and is what the Constitution requires. And so the Congress adopted that with the Citizenship Act of 1940. And so Justice Kavanaugh was suggesting that, yes, birthright citizenship is pursuant to the statute, not necessarily the Constitution. And so the key lies in perhaps looking at the statutes. But he was only one justice that said the Citizenship Act of 1940 should control.
Okay, so do you think there will be a challenge on this legally, or I guess maybe legislatively?
It's really hard to say because the Congress is so polarized. I can see the Republicans getting behind legislation to have a curb on birthright citizenship. I find it difficult that any Democrat would go along with that. But perhaps in a Congress in the future, as the birth tourism issue becomes more of a problem, perhaps another Congress will want to solve it. I don't see much happening right away, though.
How significant was it for the Supreme Court to bar men from competing in female sports? Now, I realize this kind of going the Roe versus Wade route is going to get kicked back to the states, but this does set a precedence, doesn't it?
It certainly does. I mean, there has been a great deal of controversy in these cases dealing with boys playing on girls' sports teams. There were two arguments. One was that it was Title VII of the Civil Rights Act, or Title IX, excuse me, of the Civil Rights Act, the one that really promoted girls' sports and young women's sports in colleges. And the court pretty much agreed, no, that really didn't have anything to do with transgender kids because transgender wasn't a thing back when it was passed, and the language of the statute is clear enough that it didn't involve them. The larger question was whether the Equal Protection Clause of the Constitution required women's sports teams to have boys or biological boys on those teams. And the court said no. And it was a rather strong opinion from the majority of the court. And I think that when this gets back, states are still going to choose. And I don't see any further federal interference with the ability of states to choose that unless Congress does something, which again, I don't see Congress doing much of anything anytime soon. So I think this does send a strong message to the states. If you want to ban boys playing on girls' sports teams, you state can do that, and neither the Civil Rights Act nor the Constitution are going to stand in the way.
Didn't add up, what was it, 27 states were fighting for this?
Yes.
Okay.
And more could be coming now that the green light has been given. Of course, states like California may never pass such legislation, at least for a few years. But many states realize there is something inherently unfair. And this is what is missing from a lot of the analyses I've seen, especially from the liberal side, of how unfair this is to the transgender athletes, totally ignoring the fairness and the safety issues to girls on girls' sports teams, especially in the lower grades, high school and then early college. So it really is something that I think is viscerally makes sense to people that boys should not be playing on girls' sports teams. And I think it's going to be one of those things that's not going to change, whereas unfairness in other socially fraught issues is a mixed bag. People see fairness in a different way, whether it's abortion or certain other choice issues. But I think fundamental unfairness of having boys playing on girls' sports teams is pretty apparent.
Okay, because this case being ruled the way it is, doesn't it, in a roundabout way, do away with the term transgender? And
well, you notice that the court was very clear in not referring to the people bringing the lawsuit, a child named initials BJP, not calling him a transgender girl or a transgender boy or
Right.
whatever. They
Right.
just simply used the normal pronouns in the majority opinion. The dissent, of course, did the usual liberal thing and used different pronouns and uh, called the boy a transgender girl and that kind of thing. But I think that the transgender advocates, from what I've been reading lately, think that this is just simply a temporary setback, like the early cases when gay marriage was prohibited by the states. But I don't see that being the case because there is something fundamentally unfair about having young men compete on young women's sports teams.
Yeah, I was what little I read on this, I thought, well, they really wiped out the term transgender because they used male, female, boy, girl. And at the end of the day, that's what it is. You can put any other title you want to it, but at the end of the day, it's male versus female. So I think the term transgender may be in trouble here, which is good. All right, let me take a quick break. Let me say to our viewers and listeners, go to Jim's website, pacificlegal.org. And again, Jim and his crew, they're frontline warriors in your behalf. Check them out, and you can follow a lot of these cases and a lot of the things that we're talking about here and certainly support them. And check out Jim's personal book if you're involved and want to know what's going on with the housing crisis in America. He nails it right on the head there. Nowhere to Live, the hidden story of America housing crisis. Let's get government off our back and build our homes. We'll be right back. All right, welcome back. Always an honor to have with us Jim Burling. Jim is now the senior legal counsel there at Pacific Legal Foundation. This organization is there for you, doing your work, protecting your rights. PacificLegal.org is the website. And if you're interested in real estate and housing development and all the issues that go with all of that, which is quite complex, Jim has written about it. It's one of his passions. It's called Nowhere to Live, the hidden story of Americans' housing crises. And there's a picture of the cover of the book. You can get that online. Jim, the other big decision that came out, it did give the president authority to remove agency heads. Pretty significant, don't you think?
Oh, it's extremely significant. And this is what I was alluding to in the last segment. 91 years ago, President Roosevelt tried to fire the head or one of the commissioners on the Federal Trade Commission. And he was rebuffed by the Supreme Court, saying that he did not have the ability to fire a person in the executive branch. And that has stuck in the craw of conservatives and people concerned about separation of powers for generations now. The Roberts Court was slowly eroding it over time, and they finally did away with that case called Humphrey's Executor, because Humphrey was the name of the person that President Franklin Roosevelt fired. And in this case, the most recent case, the Supreme Court reversed Trump versus Humphrey's Executor, saying the president can fire the head of an independent agency, with an exception, which we can get to, of the banking industry. But it stands for the proposition that the federal government the executive branch is controlled by the president, and agencies, which are executive agencies, are also controlled by the president. And how can the president control those agencies? The president can control them by firing the people that are head of those agencies if those people do not do what the president thinks is wise. So this gives the president a tremendous amount of power that he lacked up until the Supreme Court opinion. And it's going to cause, I think, Congress to rethink the power that it gives to administrative agencies. For a long time, Congress has been giving administrative agencies, calling them independent, giving them vast amounts of power, removing them from the ability of the president to fully control them. And the agencies have grown topsy-turvy ever since. And as some of the justices pointed out, part of the problem is that their agency heads are unaccountable to anybody but themselves. president can't fire them, Congress can't fire them. Well, we can fire them if they're caught stealing money or committing crimes and things like that. But by and large, for policy reasons, they couldn't be fired. So now the president has a great deal more power than he did. And the question is, what's Congress going to do about that?
Is it at will firing?
It is at will firing now. It was for cause. For most of the independent agencies now, certainly the Federal Trade Commission, it is for any reason or no reason at all that the president wants to fire somebody. So the at cause requirement has been removed, except for the question of the bank, the federal banking system. There, in another case, companion case, Trump versus Cook, Trump tried to fire Lisa Cook, alleging that she had lied on some mortgage statements, and that was kind of for cause, but there was no procedure given. And the Supreme Court struck that back. Now, it didn't say that he couldn't fire her, but he could fire her only for cause, and the cause had to be something that was provable, with some sort of process that the court didn't define. So by and large, the president, for most independent agencies, except for ones dealing with the Federal Reserve, most of the heads can be fired at will.
I'm just kind of curious. I wonder if this sets a standard for states and governors down the road.
It probably does not, because the separation of powers is much stronger in most federal constitutions than it is in the federal constitution than it is in most states.
Yeah.
Although sometimes legislatures and presidents can take the lesson from what happens in the Supreme Court, so that seems like a good idea and we can do that, but certainly it doesn't control them.
So if the president can fire a head of an agency at will, that suggests that that agency leader is accountable to the president. That would include the funding and the accounting and the expenses of their department, wouldn't it?
Well, only to a point. And this is the interesting thing about the federal constitution and separation of powers. While the president can control the hiring and firing, budgetary matters begin with Congress, and Congress sets the budget. Now, once an agency has the money, exactly how it's spent and what the policies are and what the regulations it adopts, that's the president's role. So the intersection that we have with separation of powers in the federal government is very complex, to put it mildly. And nobody's really actually figured it out completely yet, how, which happens where to whom, because the Constitution is a little vague on this. And that's why this case is, 250 years after the Declaration, 220 or so, 30 after the Constitution was adopted, we're still figuring this stuff out. But I think that Congress can still control the purse strings, but the government, the president controls exactly how they are spent.
Wow. I can't help but think we're going to see some turnover here.
In the Supreme Court?
No.
There were...
No, in these agencies.
Oh, of course. Yes, I think not only this president, but the next president and the one after that, we're going to see a lot more turnover when presidents change terms.
Yeah.
Because if the head of an agency is political, and the head of the agency back under Franklin Roosevelt, Mr. Humphrey, was a very political person, he was fired, and the Supreme Court said he couldn't. Now, if you have political appointees head of these agencies who act in a political way contrary to the president's will, they're going to be looking for a new job.
So there is rumor that the president's got this short list of potential Supreme Court justices, if need to be. Do you sense somebody retiring?
No, not right away. There were rumors that Justice Alito was about to retire. I mean, if you may have heard National Public Radio mistakenly put out an announcement that he had, but that was a mistake. And so far, it's usually at the end of the term when justices decide they want to retire. People thought maybe Alito would, so the president would have a Republican Senate to approve his nominee, but Alito is staying put. Thomas is staying put. And I don't see any immediate retirements, although some of these justices are getting a little long in tooth, and maybe time for younger people to take over. But that's entirely up to them. They have a lifetime appointment, and Some of them want to stretch it out for a good part in their lifetime. Why retire when you can have so much power?
Well, at the end of the day, it's highly political. I can't imagine even a conservative justice wanting to get out now, not knowing what the midterm will produce in the way of a Senate. So
yeah, I mean, if you were going to get out now, today would be the day to do it, to get the approval before the next Senate comes in. And even with the Senate as it's constituted now, there are no guarantees, because we have some mavericks in the Senate who are not very happy with the president because of his support of the opponents in the primaries, for example. So we have uncertainties, but boy, after this next election, if the Senate goes Democratic, then those conservatives will stay on even that much longer.
Anything out of this term surprise you, Jim?
I was surprised by the degree to which the court ruled on the separation of powers cases in favor of the president. I thought they'd be a little more constrained than he was, but the Supreme Court did what it thought it had to do. The Supreme Court didn't take up as many cases as many people would have liked. The Supreme Court also has been doing a lot on these interim appeals, these interim decisions. So we are seeing some of the, or also called the shadow docket, we're seeing courts, the court trying to maintain the status quo in a raging sea of fury and politics going on outside the chambers.
All right, so we're in this pause period, getting ready for the next term. You see anything down? Are you guys involved in anything going into the next term?
We have cases we're asking the court to take, but they have not yet taken any of our particular cases. But I think some of the cases that are coming up are quite interesting, that people are going to be looking at pretty clearly. One of the cases that I think is most interesting is, there's another one dealing with transgender issues, if we use that term, International Partners for Ethical Care versus Ferguson. State of Washington has a law saying that if a kid runs away, that kid can start undergoing treatments to change his or her sex without notifying or consent of the parents. Parents are arguing that's an incursion on their parental rights. The Supreme Court has taken that case up. So we will see the next step on parental rights from there. We have cases dealing with voter ID, a case Republican National Committee versus Mi Familia Vota, and that's whether the National Voter Registration Act or federal consent decrees prohibit Arizona from requiring proof of citizenship when you register to vote. Another big case that's part of the president's agenda, as we all know. It is unlikely the Senate will pass something, but states might be able to, depending on how this case comes out. So I think we have a number of these cases continuing on really hot button issues, and we'll probably see some more.
Do you think there'll be any work further down the line, so to speak, on judicial reform, judicial accountability, primarily rogue judges?
The people, yeah, you see my long side there. Accountability is great for you and it's great for the other guy. But when you talk about accountability for yourself, no, I know the rules. I'm a good person. I don't need anybody. I don't need to be accountable to anybody else but myself.
Yeah.
And I don't see the court doing much more than it's already done. There's a little more transparency here and there, and maybe a little more explaining. But as far as being having any major revisions in what the justices do or what control the lower courts, I don't see that happening. I think the Supreme Court has enough trouble sometimes keeping the lower courts in line and trying to keep itself in line. Maybe not in my lifetime.
All right, got it. One other quick question, short amount of time. The War Powers Act always come up. It's always controversial, and it's never really well defined. What's your take?
The Congress has played around with the idea of reforming the War Powers Act. Somebody's got to challenge that, and somebody with standing has to challenge that. And that's the problem. The courts have been avoiding the War Powers Act. And this, of course, is the law that says that the president can commit troops and powers in circumstances unilaterally, only coming to Congress later on for authorization. And does that give the president too much power? Some people think so. Congress says Congress shall. I mean, the Constitution says Congress shall declare war, not the president. And we'll see how this plays out. Congress and the courts may have enough, have one or two or five wars down the line.
Okay, thank you, Jim. You're always a delight. Thank you, sir, for your time. You always give it to us. Let me say to our viewers and listeners, check out the website. Check out his book, Nowhere to Live, The Hidden Story of the American Housing Crisis. Check out his book. There's a picture of the cover of the book. And again, check out the organization and support them. Thank you, Jim. God bless you, friend.
You too. Bye.